Good morning. Are you Jamie Story?
Yes, ma'am.
And Mr. Rojas, will your client waive the formal reading of the motion?
She will, Your Honor.
Ms. Story, in cause number 23, DCCR 1546, I have a motion to revoke your community supervision. Shows that you were placed on probation February 25th of 2025 for the state jail felony offense of theft of property with previous convictions, and that was enhanced to a third-degree felony because of some prior felony offenses. And it looks like the punishment was assessed at 10 years with a 10-year probation. Is that correct? This motion alleges that you violated your probation. Count 1 alleges that you failed to report to the probation department January 29th, February 12th, and February 26th of 2026. And is that true or not true?
No.
True or not true? Count 2 alleges that you failed to work faithfully at suitable employment and provide verification of that. And is that true or not true?
True.
Count 3 alleges that you failed to immediately report to the probation officer your contact information. And is that true or not true?
True.
Count 4 alleges that you failed to provide verification of performing the community service hours required. Is that true or not true?
True.
Count 5 alleges that you failed to complete the mental health assessment and follow all of those recommendations. Is that true or not true?
True.
Count 6 alleges that you failed to provide verification of completing the theft prevention class. Is that true or not true?
True.
And finally, count 7 alleges that you're behind in your court assessed fees. And is that true or not true?
True.
Did you enter your pleas of true to counts 1 through 7 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're all actually true?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow this agreement that you've made, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've made is for a cap of 6 years in prison, which means if I follow that agreement, I can give you 6, I can give you less than 6. It'll all depend on the information that's brought to me when we come back for a sentencing hearing. And is that what you want me to do?
Yes, ma'am.
All right, state tender's number 1.
No objection.
It's admitted any evidence Ms. Story is not competent.
No, Your Honor.
All right, ma'am, I'm going to find that you entered your pleas of true to counts 1 through 7 freely and voluntarily. Find those counts true, find sufficient evidence to revoke your probation, but I'm going to reset your case for sentencing so that the probation department can do an updated report. Also, anything that you think is important for me to know, get that information to Mr. Rojas and he'll present it to me on your behalf when we come back. All right, you can go back with the baby.
All right, thank you.
Judge, my last one is Willie Pugh. He was set yesterday for a suppression hearing.
Let me just,
Uh,
Washington Wood Jr. And Mr. Wood, in cause number 25, DCCR 1650, you're charged with a third-degree felony offense of failure to comply with sex offender registration requirements. That's from July 30th of 2025. The indictment alleges that you were also previously convicted of burglary of a vehicle, a third degree, burglary of a building, a second degree, another burglary of a vehicle, third degree, and an unauthorized use of a motor vehicle, a third degree, on January 27th of 1986. And after those were final, you were convicted of theft, a third degree, January 22nd of 2019. You guys have marked off second degree, but would it
Should
not
be
be a
first.
habitual?
It's not habitual because
It could be because they did not include in the indictment the underlying sexual assault offense that caused him to have to register.
Okay. So
That would be a notice I would make
a
on my
notice,
own.
and that would make it a habitual, correct? So, Mr. Wood, I want to make sure you understand that if you go to trial and you're found guilty and the state files that notice of enhancement with the prior felony conviction that's not in this indictment, that you could be considered a habitual offender with a minimum punishment of 25 years up to 99 years or life in prison. Do you understand? And I have a plea bargain rejection here on the tablet that you've signed with Mr. Parker that shows that the district attorney's office has made an offer. If you wanted to enter a plea of guilty, looks like to go forward probably on count 1 only for a 10-year term in prison. You have every right to reject that and have your case set for trial. I want to make sure you understand what the possible consequences are if you go to trial, what your options are if you wanted to plead guilty. Do you understand all of that? Sorry.
Yes, ma'am.
And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
Is there any reason to believe that that offer would change, Ms. French?
Mr. Parker may have information for me that might cause that offer to change. Can we reset? Just how long, Mr. Parker? What do you say?
I mean, I don't know what I'm gonna provide you other than what I've told you. I'm not gonna have any documentation. I mean, with he's on parole, Judge. He has 2 types of cancer. He has some health issues and quite bluntly, he's, anytime he gets, he thinks is a death sentence. And so, I mean, that's his position, understand it. But I don't know if his position is gonna change.
So let's just do this. So, Mr. Wood, I'm going to place your case on the trial docket. If anything changes between now and then, the attorneys can let me know. We can get you back in here sooner. Mr. Parker has been appointed to represent you at this point. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and I can appoint another attorney who could begin preparation for trial a little quicker. Is that okay with you?
Yes, ma'am.
All right, so Mr. Parker, you're released. Mr. Wood, we will appoint someone today. They should be out there to see you very soon to begin preparation for trial.
Judge, I have the McWade file.
Young? And Mr. Parker, will your client waive the formal reading of the motion?
She will, Your Honor.
Ms. Young, in cause number 24 DCCR 0402, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation January 6th of 2025 for the 2nd-degree felony offense of assault on a peace officer. And that was a 5-year deferred probation. Is that correct?
Yes.
This motion alleges that you violated your probation. Count 1 alleges that you committed the new offense of hindering apprehension or prosecution November 18th of 2025. And is that true or not true?
Sure.
Count 2 alleges that you violated the terms and conditions of your probation by knowingly associating with and harboring Raimi Jamal Prevost. And is that true or not true?
Sure.
Count 3 alleges that you provided a urine sample April 9th of 2026 that tested positive for marijuana. And is that true or not true?
Sure.
Count 4 alleges that you failed to provide verification of performing the community service hours. Is that true or not true?
Sure.
And count 5 alleges that as of April 15th, 2026, you were $308 behind in your fees. Is that true or not true?
Sure.
Did you enter your pleas of true to counts 1 through 5 freely and voluntarily?
Yeah.
And did you plead true to those counts because they're actually true? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yeah.
Do you fully understand them?
Yeah.
And do you understand if I follow this agreement that you'll be waiving or giving up any right to appeal?
Yeah.
And it looks like the agreement that you've reached is for me to continue you on probation, extend that probation 2 years, and also order that you enter and successfully complete the cognitive track of the ISF program. Is that your understanding?
Yes, ma'am.
State tenders number 1.
No objection?
It's admitted. Is there any evidence that Ms. Young is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your pleas of true to counts 1 through 5 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that. This is a big opportunity that you're getting today. I'm going to extend your probation for 2 years. I'm going to order that you enter and successfully complete the cognitive track of the ISF program. If you do all of that, you're still in a great position because you can still finish this probation and not have a conviction on your record. But you're obviously going to have to make some better decisions. What's the relationship with?
That's the problem.
Your Honor, the court amended her probation several months ago, ordered her to not have any contact with Mr. Prevost. He is, I believe, awaiting sentencing or waiting disposition of a aggravated assault motion to revoke probation next door.
Okay.
He is out, and she needs to be aware that she needs to cease communication with him.
No.
I mean, if you were already told that, and I'm having to tell you again, then you're not going to be told a third time.
Yeah.
I don't care what the relationship is. It's up to you to decide if that relationship is worth you going to prison. So, because that's where you'll end up if you're back in here, So I can't imagine that any relationship it would be worth that. I hope you take advantage of this. This was an agreement that I followed, so I'm handing you the trial court certification. And you'll go to ISF, and then when you're out, just do everything you're supposed to. All right?
90-day for.
Yeah, I think it's close to 90 days. All right, you can go back with the bailiff. Mr. Nichols, have you had an opportunity to review your file?
I have, Your Honor. It appears that there was a bond hearing May 5th, 2026. And I think the court heard evidence at that point concerning this offense and another offense.
I did. I mean, but there was a previous one. I don't know the exact date, but it was sometime. It was just like, let's see. So is there any change that you see, Mr. Nichols?
No, Your Honor, I don't.
Any reason would you, any agreement or reason that I would reduce the bond?
No, Your Honor. I would just re-urge everything that you've been over before. Ask you to keep it how it is.
Give me just a second to go back and look at the PC to remind myself what the allegations was.
The allegations concern him having a fight with a female in the vehicle, stabbing her with a pocket knife while she was driving and then causing the vehicle to crash.
We naturally kind of disagree with her version of the facts.
Speak up, please.
We naturally disagree with her version of the facts. Mr. Mullins and Mr. McWade were in a relationship, and this was a fight that escalated. Changed since the last time is he now has definite employment waiting for him at Neutron Electric. What is their name? Neutron Electrical. He's a electrician and would go there and work and live at home with his parents. And have nothing to do with Miss Mullins.
Give me a second. I'm just looking at a couple of things. All right, I'm not inclined at this time to modify that prior ruling. I will look back and have the court reporter pull up to make sure that we didn't discuss anything about the job, but at this point, we just need to get the case set for whatever it's gonna get set for.
I believe there's been a rejection, Your Honor.
Yeah, it's set for trial.
Oh, it's already on the trial docket.
It's set for September 14th.
Okay, all right, then, well, I'll do my best to see if it can be at the top of the list on that day. If for some reason it's not reached on that week, then at that time I would consider an additional motion.
Okay,
Because
thank
I
you.
would consider that new, obviously, if he has to sit and wait for another trial docket. Okay,
Thank you.
all right, thank you.
Good to see you.
That's an order for a setting. Mr. Gertz, you have Giovanni Coleman. Morning.
How are you?
Good. How are you?
See how it goes after this.
Yeah. All right, you're Giovanni Coleman.
Yes, sir.
This is cause number 25 DCCR 0479. Mr. Coleman is charged with the first degree felony offense of murder. And what is the the announcement?
Judge, we are very, very close to an agreement that will resolve this case without a trial. There are some technicalities that need to be worked out and need to be approved by various people. I think Ms. Malfino will agree with that assessment. But we believe this is going to get resolved. Mr. Coleman agrees in principle with the deal that we have worked out. So
Speak up.
I'm sorry. Mr. Coleman agrees in principle with the deal that we have. And so we're asking for.
And Judge, may I just put my spin on that?
Please.
I would-
Because, and here's
I would
my
not so
concern.
strongly say that we have an agreement in place. It's not like we're waiting for the ink to dry. I think what we're saying without saying it so much is that we have had a very productive conversation, which a lot of times in these elevated first degree cases, we're not even able to get to that point. I'm not in a position to make the offer that we have discussed. And if that requires me placing it on the trial docket, knowing that I need to come to the court in advance, if that offer does make itself
Here's what we're gonna do.
doable.
You've been on since last May, so we're 14 months into your representation. Last reset, figure out what you need to figure out to whatever the offer is, it is. I want a final offer, yes or no to take it or not, and then if it goes on the trial docket, all of that needs to take place between now and that next announcement.
Okay, we're ready.
This
for
will
that.
be the last one.
Okay.
Okay, all right, you go back with the bailiff.
And that should also dispose of the code of
Thank you. Mr. Radford, you have Jacobian Dorsey.
Yes, ma'am.
Dorsey.
Did you do a rejection?
I think he's already been done, but you know.
Let me, I'll check real quick and see. Was there anything, hold on, you might not have to do one. Is there anything that's,
But he's already, I think I combat lawyers.
Looking,
we're not gonna call them that.
Okay, I'm sorry.
Mr. Coleman's notes look like he hasn't changed the offer or anything, Your Honor.
Looks like, the offer was 20
Yes, stacked.
to stack on top of a sentence he's are doing correct now, correct?
Yes, ma'am.
All right, so you're Jacobian Dorsey?
Yes, ma'am.
And Mr. Dorsey, in cause number 25, DCCR 1896, you are charged with manslaughter. And we've gone over this before. Let me pull it up. Is there the indictment alleges second-degree felony offensive manslaughter, but looks like the state's filed a notice of intent to use prior conviction to enhance your punishment, which means we've gone over before, and when you sign that plea bargain rejection with Mr. Parker, that the state, you would be looking at a first-degree felony if you're found guilty for punishment purposes, which means the minimum punishment would be 5 years up to 99 years or life in prison. You understand that? And the same offer is on the table now, which is a 20-year term in prison that would be stacked on top of a sentence that you're currently serving. Is that your understanding of what they've offered you? And you want to reject that and move forward with trial?
Yes, ma'am.
All right, we'll get it set on the trial docket. Mr. Radford will begin preparation for trial.
Excuse me, that that I'm actually doing time for right now already, that's on appeal,
Okay,
but that's not a full conviction.
all right. Well, if it'll all depend on when we get to the trial. I'll set it on the trial docket. If something gets affirmed by then the conviction would count. If not, then there's some legal issues that will take up at that time, which means it would be potentially just the 2 to 20, but we'll take that up at pre-trial.
Judge, it looks like a case has been brought over this week from something that happened in the jail, and maybe a new harassment, or assault on an officer. I think that's going before the grand jury tomorrow, if not tomorrow, next week. And I just asked that we put this on the trial docket. I don't think it's going to change.
No, yeah, we're
Okay.
gonna go to put this one on the trial docket and then we'll deal with that one when it comes.
Thank you. Your Honor.
Thank you, Mr. Nichols. You can go back with the bailiff.
May I be excused?
Yes, sir.
Thank you. Yeah, I'll go back.
And did you plead guilty because you actually did what they charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Park?
Yes.
Do you fully understand that?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number one,
Objection.
it's admitted. Is there any evidence that Mr. Bell is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of driving while intoxicated, third or more. Sentence you in accordance with that agreement to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I will also, as part of that plea agreement, sign the dismissal in cause number 25 DCCR 1211. I'm handing you the trial court certification, shows that this was an agreement that I followed, and so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Park. All right, good luck to you, sir. You can go back with the bailiff. Ronald Barrett.
Can we do?
Ronald Barrett.
Wait, go ahead. It's a common case.
Looks like Mr. Mr. Nichols is on that one.
We've got it covered.
Yep, got
I'm just letting you know, I mean, y'all wasn't saying today.
Actually, it's my case. They've been, most of it has been.
It said, oh, it said Tommy.
No, it's no longer says,
On my reset, sorry.
you've been around this. Sorry, case.
Good morning, sir. Are you Ronald Barrett Jr.?
Yes, ma'am.
And Mr. Parker, will your client waive the formal reading of the indictment?
Yes, Your Honor.
Mr. Barrett, in cause number 26 DCCR 0890, you're charged with the state jail felony offense of unauthorized use of a vehicle.
Yes, ma'am.
And that's from January 28th of 2026.
Yes, ma'am.
The indictment alleges that you were previously convicted of unauthorized use of a motor vehicle August 3rd of 2009.
Yes, ma'am.
And after that was final, you were convicted of possession of a controlled substance March 22nd of 2011.
Yes, ma'am.
And then after that, convicted of unauthorized use of a vehicle April 14th of 2011.
Yes, ma'am.
And then again, unauthorized use of a motor vehicle June 26th of 2017. And then burglary of a building August 24th of 2022.
Yes, ma'am.
And how do you plead to that charge?
Yes.
And are all those prior convictions true?
Yes, ma'am.
I don't understand this agreement at all.
Judge, the vehicle in question is a scooter taken from a unknown address. The complainant that's well known.
And I,
Both me and the court.
I will also tell that there's been some cooperation with.
Okay.
Law.
Did you enter your plea of guilty freely and voluntarily?
Yes, ma'am.
And did you plead guilty because you actually did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow this agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And obviously you can tell that I don't like this agreement, but I understand there's some circumstances that Mr. Nichols and Mr. Parker have negotiated for that.
Yes, ma'am.
I want you to understand if you come back in here on another offense where you're stealing a car or getting into a building or stealing, I don't care if it's a scooter, I don't care if it's a Snicker bar.
Yes, ma'am.
You will not get an agreement like this again, regardless of what you've done. Do you understand?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number one.
Objection?
It's admitted. Is there any evidence that Mr. Barrett's not competent?
No, you're right.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily.
Yes, ma'am.
Also that you entered those pleas of true freely and voluntarily.
Yes, ma'am.
Find that you're mentally competent and you understand the nature and the consequences of your plea.
Yes, ma'am.
Find sufficient evidence to find you guilty, and at this time find you guilty of unauthorized use of a vehicle. Find this prior offense is true. Sentence you in accordance with your agreement to a term of 2 years in the state jail, in the Texas Department of Criminal Justice.
Yes, ma'am.
You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive.
Yes, ma'am.
I've handed you the trial court certification that shows this was an agreement that I followed, so you have waived your right to appeal.
Yes, ma'am.
I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition.
Yes, ma'am.
Possession of a firearm or ammunition could lead to charges against you.
Yes, ma'am.
If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker.
Yes, ma'am.
Good luck to you, sir. You can go back with the
Thank
bailiff.
you.
All right, thank you. Sean Johnson,
It's rejection. He may be, this.
snowboarder. Isn't that his name?
Huh?
Yeah, the snowboarder.
Oh. I was thinking of the gymnast.
Oh, yeah, probably. Okay,
That's what I thought.
no, getting confused.
I'm gonna Sean White.
Yeah.
Right. Sean Johnson is the gymnast. Probably not the same, definitely.
Yes, ma'am.
Good morning, sir. Are you Sean Joe Johnson?
Yes, ma'am.
And Mr. Johnson, in cause number 26 DCCR 0924, you're charged with a second-degree felony offense of aggravated assault with a deadly weapon from March 6th of 2026. Your indictment alleges that you were previously convicted of burglary of a habitation, a second-degree felony, July 8th of 2016. And then after that was final, you were again convicted of burglary of a habitation, a second-degree felony, February 15th of 2017. And what that means, sir, is that if you go to trial and you're found guilty, you would be considered a habitual offender with a minimum punishment of 25 years in prison up to 99 years or life. Do you understand?
Yes, ma'am.
And I have here on the tablet a plea bargain rejection that you've signed with Mr. Parker, and I'm guessing you guys, it says months are checked off.
Oh, I'm
guessing
sorry.
it should be years.
I'm apologize. Yeah.
So it shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 12-year term in prison. You have every right to reject that offer and have your case set for trial. Just want to make sure you understand what the possible consequences are if you go to trial, what your options are if you want to plead guilty. Do you understand all that?
Yes, ma'am.
And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
All right, we'll get that done. Mr. Johnson, Mr. Parker has been appointed to represent you. He's one of the cases. He's one of the lawyers who handles a lot of cases for me here as a court-appointed attorney. With your permission, I can release him and appoint a new attorney who could begin preparation for trial a little quicker. Is that okay with you?
I'm gonna do a turn.
So I'm going to release Mr. Parker. We will appoint someone today, Mr. Johnson. They should begin preparation for trial very soon. Mr. Smith, is there any reason to believe or anything that you're waiting on that offer would be reduced with a different attorney? So I do want to make sure you understand that a different attorney is not going to necessarily get you a different deal. And that typically after today, I don't take those deals that you've already turned down. If something comes up that's different that your attorney doesn't know or the DA, then I'll consider it. But whoever that is will be out to see you very soon and begin preparation for trial. All right, you can go back with the bailiff.
Yeah.
See, Miss Holmes, you got Stormy Fulwell.
Wrong. Forward. Over the motion, we can do an updated PSA.
I think you need to know exactly what you're gonna do on this one, though.
Yeah.
Oh, I do. Y'all do?
Mhm.
Well, how would you prejudge? Is it that clear?
She's very clear.
Oh.
This is one of those special drug things that the minimum is 10. But she pled.
Garrett, toast now.
for-
I'm getting to get over.
She's
She's been to St. Pete twice.
Good morning. Are you Stormy Fulwell? And will your client waive the formal reading of the motion?
Yes, Your Honor.
Ms. Fulwell, raise your right hand, please, ma'am. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. You can put your hand down. Ms. Fulwell, in cause number 21-38655, I have a motion to revoke your community supervision. Shows that you were placed on probation January 26th of 2022 for possession with intent to deliver a controlled substance, a first-degree felony. And that was a 10-year term in prison that was probated for 10 years. Is that correct? The motion alleges that you violated your probation. It alleges in count 1 that you provided a urine sample January 26th of 2026 that tested positive for methamphetamine. Is that true or not true?
January 22nd.
January 22nd of 2026, excuse me. Is that true or not true?
Yes, sir.
True or not true? Thank you. Count 2 alleges that you failed to provide verification of performing the community service hours as required. And is that true or not true?
True.
Count 3 alleges that you failed to successfully complete the SafeP program and that you were unsuccessfully discharged from the supportive outpatient treatment on January 22nd of 2026 because you tested positive there for methamphetamine, amphetamine, and ecstasy. And is that true or not true?
True.
Count 4 alleges that you failed to submit to alcohol or drug screening January 21st and February 2nd of 2026. Is that true or not true? But that is not true. Count 5 alleges that you're behind in your court assessed fees as of February 6th of 2026 in the amount of $4,205. Is that true or not true?
True.
Did you enter your pleas of true to counts 1, 2, 3, and 5 freely and voluntarily? And did you plead true to those counts because they're actually true? All right, then I'm going to find that you entered your pleas of true to counts 1, 2, 3, and 5 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation. I'm going to reset your case for sentencing and ask the probation department to do an updated report that'll give me more information about what's been going on. Also, if there's anything that you think is important for me to know, get that information to Ms. Holmes and she'll present it to me on your behalf when we come back. All right, you can go back with the bailiff. Thank you for being here, ma'am. Jasmine Hancock.
Yes. Those are the objections.
Okay.
Yeah.
Good morning, sir. Are you Jasmine Tyrone Hancock?
Yes, Mom.
And Mr. Hancock, in cause number 25 DCCR 0737, you're charged with the state jail felony offense of evading arrest or detention with previous convictions. And that's from April 22nd of 2025. The indictment alleges that you were previously convicted of evading arrest or detention August 9th of 2013. Some of these are with vehicles, which would make them different. Looks like we've got an evading with a vehicle, April 23rd of 2008, another evading with a vehicle, December 1st of 2008, and evading with previous convictions, June 12th of 2017, and evading also with previous convictions, June 12th of 2017, and evading with a motor vehicle, 2 cases on June 12th of 2017. Then the indictment further alleges that you were convicted of unlawful possession of a firearm by a felon, February 9th of 2009. Also possession of a controlled substance on that same day. And then after those were final, you were convicted of burglary of a habitation, June 12th of 2017. Well, what that means is that if you go to trial and you're found guilty and those prior convictions are true, the range of punishment would be that of a second-degree felony, which is between 2 years and up to 20 years. Do you understand?
Yes, Mom.
So in clause number 25, DCCR 0738. You are charged with the third-degree felony offense of continuous violence against the family, and that's from April 26th of 2025. And it alleges those same prior felony convictions, which in this case means that if you go to trial and you're found guilty, the range of punishment would be that of a habitual offender, which is a minimum of 25 years in prison, up to 99 years or life. Do you understand that as well? And then we've got cause numbers 25 DCCR 1233, which is another evading arrest or detention with previous convictions, and that's from August 5th of 2025. And then we've got 26 DCCR 1018, which is also an evading arrest or detention with previous convictions from March 18th of 2026. Those are both the same as that first one with those prior offense convictions that would make these second-degree felony offenses for punishment. You understand that? In all four of these cases, I have here on the tablet some plea bargain rejections that you've signed with Ms. Holmes, and it looks like the district attorney's office has made offers if you wanted to enter pleas of guilty. For the evading arrest or detention cases, it looks like it would be cause number 250737 and
I think
1018. There would be 12-year terms in prison with dismissals in the other evading and that continuous family assault case. You have every right to reject those offers and have all of your cases set for trial. I want to make sure you understand what the possible consequences are if you go to trial and what your options are if you want to plead guilty.
Good.
You understand all of that.
Good.
I also want to make sure you understand that if you are found guilty on more than one of these, because they're different offense dates, there is the possibility that any sentence you receive on more than one could be stacked on top of each other. Do you understand that?
Yes.
And do you want to reject all of these, the offers on all of these cases and have them all set for trial?
Yes.
Mr. Nichols, is there any reason to believe that these offers would change or?
No, Your Honor.
So I do want to make sure you understand also, Mr. Hancock, that after today, I will not accept these plea agreements.
Yes.
Once your case goes on the trial docket, it goes to trial, or you can enter a plea either open to the court or to some different.
Yes, ma'am.
You understand all that?
Yes, ma'am.
All right, then we'll get it set on the trial docket. Mr. Hancock, Ms. Holmes has been appointed to represent you at this point. She's one of the attorneys who handles a lot of cases for me as a court-appointed attorney.
Yes.
With your permission, I can release her and appoint another attorney today who could begin preparation for trial a little quicker. Is that okay with you?
Yes, ma'am.
So Ms. Holmes, I'll release you. We will appoint someone today. They should be out to see you at the jail very soon to begin preparation for trial.
Yes, ma'am.
All right, you can go back to the bailiff. All right, on Jonah Johnson. Good morning, sir. Are you Jonah Johnson?
Yes.
And Mr. Johnson, in cause number 25, DCCR 1775, you're charged with a second-degree felony offense of aggravated assault with a deadly weapon. And it looks like. Has there been I guess I'm confused. Because the offers,
25 should be 20. It's 2 to 20.
it's a 2 to 20, and I don't see, is there going to be, or has there been, I don't see a notice of extraneous other convictions.
There is no, that's right, Judge. It should, the max is 20, Judge.
So really, there's no offer. It's just to plead open or plead guilty to the max. Is that?
Judge, I was on the impression it's first degree. Let me
Punch up,
draw
okay.
that offer.
Yeah.
The state's offer now is 15, Judge.
Okay, I'll hold it for a minute if y'all want to visit about that, or I can.
We've already talked about that.
Okay, so it doesn't matter if
It
it's-
doesn't matter.
Okay, so with everybody's permission, I'll make that change here on this
Thank you.
document.
Please, Judge. Thank you.
All right, so Mr. Johnson, what that means in your case is that if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 20 years in prison. Do you understand?
Yes.
And I have the plea bargain rejection that you've signed with your attorneys that shows that the district attorney's office has made an offer of 15 years in the institutional division. You have every right to reject that and have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial, what your options are if you wanted to plead guilty.
Yes.
You understand all of that?
Yes.
And you want to reject that offer and have your case set for trial.
Yes.
All right, we'll get that done. Also, is there any reason to believe any evidence that you haven't either received or waiting on, or that would change this offer?
No, Judge.
And as far as you guys know, y'all asked for, everything's been received through the portal. Any media? Is there anything else that's outstanding that you know of,
Oh, no.
media wise?
No, Judge.
Okay. So y'all have requested and received the media, if there is any? Perfect. Okay, so I just want to make sure you understand that after today, unless there's some new evidence that comes up that your attorneys or the district attorney does not know about, I will not accept this plea agreement. So after today, it goes on the trial docket, it'll go to trial, or there'll be a plea to something else, or if it's going to be this or lower, it would be because there's some new evidence. Does that make sense?
Yes.
All right, we'll get it set on the trial docket, and we'll let you guys will get a notice by email.
Judge, may I ask this court's permission? This is my first time trying
Sure.
to case for you.
Yes, sir.
Does this court set kind of like a docket control order where there might be a motion setting or anything?
So
like that?
what I do is I'll set a pretrial
Okay.
the week before the trial date.
Okay,
And typically our trial dockets are about 8-ish cases or so. And so on the pretrial, I will go through and see who's ready, who's not ready, whatever the case is. And then I'll order those for the next week. So you would know on the Tuesday prior to what number you are. If you're at the top or close to it and there's some pretrial issues that we need to deal with, we could do it on that day. Or if it's the number one case, we can do it on that Monday before jury selection, depending on what those pretrial motions are.
okay.
If there's something that is going to require more time, some type of suppression or some hearing that will take witnesses and more time, please get that filed quickly and I'll get it set well before that so that we can have that taken care of.
Yes, ma'am.
Okay?
All right. Thank you, Judge.
All right. Thank y'all.
May be
Thank you.
excused.
Yes, sir. You go
Thanks,
back with the bailiff.
All right, we'll see.